Los Angeles as the speaker for the defense, Your Honor.
Granted. Proceed.
Your Honors, my countrymen, after 42 hearings, there are two matters I wish to discuss. First, whether the confidentiality of foreign currency deposits under Republic Act 6426 is a justification not to disclose dollar accounts in the SALN. Second, if it is not a justification, whether its non-disclosure in the SALN amounts to an impeachable offense. Your Honors, the confidentiality under Republic Act 6426 justifies a public official from disclosing his dollar accounts in his SALN. RA 6426 provides that all foreign currency deposits, without any qualification as to whether they are owned by a private or a public person, are absolutely confidential, except upon the written waiver of the depositor. Even if Section 8 Republic Act 6713 requires public officials to file a SALN under oath, this provision does not amend the confidentiality of dollar deposits under the Foreign Currency Deposit Act, which is a specific law. Besides, our Constitution provides, under the Bill of Rights, a right to privacy and a right to information. I posit that the right of access to the SALN of public officers is covered by the right to information. However, in Republic versus Eugenio, the Supreme Court ruled that bank accounts are not covered by the constitutional provisions regarding the right to information and full disclosure. And I quote, "Unless the Bank Secrecy Act is repealed or amended, the legal order is obliged to conserve the absolutely confidential nature of Philippine bank deposits. Any exception to the rule of absolute confidentiality must be specifically legislated." When the Supreme Court issued the temporary restraining order in favor of PS Bank, Justice Arturo Brion, in his concurring opinion, not only cited the Eugenio case, but added, and I quote, "Notably, the court declared that bank accounts or the bank accounts law are not covered by the right to information under Article 3, Section 7, and the requirement of full public disclosure under Article 2, Section 28 of the Constitution, which is statutorily implemented through Republic Act 6713. According to Justice Brion, Republic Act 6713 did not repeal Republic Act 6426, and I quote, "The implied repeal of inconsistent laws that Republic Act 6713 mandates cannot be interpreted as a repeal of the express substantive right granted to confidentiality under Section 8 of Republic Act number 6426, even if the latter was enacted earlier. Implied repeals are not favored. The presumption is against inconsistency or repugnance, and accordingly against implied repeals. In BSB Group versus Go, the Supreme Court also ruled that in case of doubt, the confidentiality of bank deposits should be favored. The court said, and I quote, "Should there be doubts in upholding the absolutely confidential nature of bank deposits against affirming the authority to inquire into such accounts, then such doubts must be resolved in favor of the former. This attitude persists unless Congress lifts its fingers to reverse the general state policy respecting the absolutely confidential nature of bank deposits. We cannot therefore hold the Chief Justice liable because he believes in all good faith in the absolute confidentiality of foreign currency deposits. It is argued by some, however, that insistence on the rule of absolute confidentiality will provide a safe haven for grafters and corrupt public officials who will simply conceal their ill-gotten wealth as dollars, never to be reported or declared. They say that the Chief Justice is wrong to adopt the view favoring absolute confidentiality of foreign deposits, and that therefore he must be convicted. While there may exist a danger that corrupt officials may escape discovery, let us not mistake the Chief Justice's use of this interpretation for the possibility of its abuse. In this case, there is no showing that the non-inclusion of certain bank accounts was tainted with any malice or fault. What we have here is a situation where the Chief Justice, consistent with his practice for the last 2 decades, assumed that his reliance on the letter of the law could not be wrong. Yes, there may be what we call a lacuna in the law, a gap or a hole, which may pertain to an unsettled question of law. In this case, the gap may have to do with the confidentiality of dollar deposits vis-a-vis the duty of public officers to disclose their assets and net worth in the SALN. Notably, even BIR Director Estrella Martinez, in all her 32 years of SALN examination, did not find any public officer who disclosed a dollar deposit. Plainly, all these public officials understood RA 6426 and 6713 in the same manner as the Chief Justice. We are all aware that the separation of powers requires us to look only to the Supreme Court decisions as definitive interpretations of the law. To this day, however, there is no ruling that squarely applies to the confidentiality provided under RA 6426 with respect to the SALN. The alternative to filing this lacuna or to filling this lacuna is through an express repeal by amendatory legislation. In both cases, the results of these processes are decidedly prospective. In other words, the Chief Justice cannot be made answerable for his interpretation of the law prior to a Supreme Court ruling or legislative amendment, explicitly declaring his interpretation as erroneous. To repeat, there is no liability for an erroneous interpretation of the law when made in good faith. The Chief Justice, Your Honors, has acted consistently, unwavering in his conviction and belief that RA 6426 affords him full and absolute confidentiality. As held in Francisco versus nagmamalasakit na mananananggol, just because he is the Chief Justice does not imply that he gets to have less in law than anybody else. The law is solicitous of any individual's rights, irrespective of his status in life. Even if we assume that the Chief Justice should have disclosed his foreign currency deposits in his SALN, it is submitted that this non-disclosure in the SALN will not amount to an impeachable offense. Section 2, Article 11 of the Constitution provides that the President, the Vice President, the members of the Supreme Court, the members of the Constitutional Commissions, and the Ombudsman may be removed from office on impeachment for and conviction of culpable violation of the Constitution, treason, bribery, graft and corruption, other high crimes, or betrayal of public trust. This enumeration indicates that the impeachment and conviction of these high government officials should be based on nothing less than high crimes. Treason is abominable because it is an act of disloyalty to our country. It carries a penalty of 12 years and 1 day to death. Bribery is penalized by 6 years and 1 day to 12 years. Graft and corruption also carries a penalty of not more than 10 years. Betrayal of public trust, which is unique to the Philippines, must also be based on a serious crime with a high penalty. For certainly, the high government official should not be impeached and removed from office for a minor breach of the law. In this case, Chief Justice Corona is not charged with treason, bribery, graft and corruption, or even ill-gotten wealth. Article 2 of the Articles of Impeachment accuses the Chief Justice of not disclosing his SALN to the public. The Chief Justice is, however, exempted from any liability for the disclosure of his SALN. He is bound by the resolutions of the Supreme Court and Bank regulating their release to the public. It is also said that the Chief Justice did not disclose all his assets in his SALN. We have painstakingly shown, however, that the real properties allegedly belonging to the Chief Justice are not actually his, and therefore need not be disclosed in his SALN. The remaining issue is whether the non-disclosure of his other peso and dollar deposits amounts to a culpable violation of the Constitution and or a betrayal of the public trust. The defense has shown that the peso holdings or deposits of the Chief Justice were disclosed in his SALN. The other peso accounts do not belong to him, but are either owned by his children or held in trust for Basa Guidotti Enterprises or as part of the common fund from his mother. The Chief Justice relies on the basic principle that what he does not own, he should not declare as his asset. It is therefore submitted that he cannot be held liable for culpable violation of the Constitution. His dollar accounts were not included for reasons earlier stated. according to Committee Report number 1214, in the impeachment of President Elpidio Quirino, a violation of the Constitution committed unintentionally or involuntarily or in good faith or through honest mistake of judgment is not a ground for impeachment. Similarly, the Chief Justice cannot be held liable for betrayal of public trust. Father Joaquin Bernas explained that betrayal of public trust implies deliberate intent and perhaps a certain degree of perversity, for it is not easy to imagine that individuals of the category of these impeachable officials would go so far as to defy knowingly what the Constitution commands. It must be of the same gravity as the other offenses in the class. In other words, not every violation of public trust is an impeachable offense. It is therefore respectfully submitted that the failure to disclose in the SALN his dollar accounts will not amount to an impeachable breach of trust. Indeed, the penalty of violation of the SALN is only a fine not exceeding 5,000 pesos or imprisonment not exceeding 5 years, or both, which cannot compare with the severe penalties for treason, bribery, and graft and corruption. More importantly, even before we can get to the matter of penalty for non-disclosure or non-inclusion, RA 6713 itself provides a corrective measure under Section 10 thereof. Per force of logic, there is no violation of law where the law itself provides a corrective measure. All that needs to be done is to call the attention of the public officer. This is the remedy of first resort, not to punish him, much less to remove him from office. I further wish to point out that pursuant to the separation of powers, our Constitution vests the important role of impeachment in Congress, hoping that it will act independently in hearing the impeachment of the officials of the other branches. Regrettably, we have witnessed the unusual rubber stamping by the majority of the House of Representatives, who never even read the articles of impeachment. The blitzkrieg endorsement of the articles of impeachment to the Senate was principally undertaken by the party mates of the President. The President then repeatedly declared that he wanted the Chief Justice removed. In support, the executive branch then lent its full and awesome powers to interfere in the impeachment proceedings, to oust the Chief Justice, and to intimidate the Supreme Court. For example, the Secretary of Justice threatened other Supreme Court justices with impeachment. The Land Registration Authority then falsely listed 45 alleged properties of the Chief Justice. The Bureau of Internal Revenue divulged confidential income tax returns and commenced investigation of the Chief Justice and his entire family. The AMLAC looked into the bank accounts of the Chief Justice without a predicate crime or court order. The Ombudsman exaggerated and testified that the Chief Justice has 82 bank accounts and $10 to $12 million in deposits. The Commission on Audit disauthorized the purchase of the Basagidotti property after 11 long years. Decadence of their actions imply a conductor. Such undue interference by the executive department in order to undermine the judicial department is clearly intended to weaken and then control the latter department, to do away with effective checks and balances under a tripartite government system. Under the pretext that the Chief Justice and the Supreme Court are impediments to reforms sought by him, the President aims to remove the Chief Justice and make the Supreme Court subservient to his whims. It is our fervent hope that the Senate will not lend its assistance to this plot. Let not this institution allow the guillotine to fall on the judicial independence. During the time of U.S. President Franklin Delano Roosevelt, a similar situation occurred. After being repeatedly rebuked by the Supreme Court, a peeved President Roosevelt wanted to undermine and control the judiciary by seeking to create additional positions in the U.S. Supreme Court so that he could appoint a majority of the members. In refusing to pass the amendment, the U.S. Senate Judiciary Committee wrote in its report, and I quote, "Let us, of the 75th Congress, in words that will never be disregarded by any succeeding Congress, declare that we would rather have an independent court, a fearless court, a court that will dare to announce its honest opinions in what it believes to be the defense of the liberties of the people, than a court that out of fear or sense of obligation to the appointing power or factional passion approve any measure we may enact. We are not the judges of the judges." Finally, the case of the Chief Justice is not complete without reference to the fundamental right to the presumption of innocence. We have seen the absolute lack of any damning evidence presented against the Chief Justice, even where it was alleged by the prosecution that his acts are punishable violations. The defense has shown that the Chief Justice relied on sound legal basis for his position, and in all instances guided by good faith and without malice. But beyond what the prosecution failed to prove, what strengthens the presumption of innocence is the credibility of the Chief Justice in giving justice, in proving himself forthright, courageous, and true. His innocence is buttressed by the common sense truth behind his testimony, affirming the experience of many Filipinos in their own families. His courage is shown by his dauntless determination to fight this impeachment and the horrid cesspool of propaganda along with it. Most of all, he has responded to the call of the Filipino people by defying all expectations and raising the bar for all public officials. Despite his reliance on the confidentiality of RA 6426, the Chief Justice has, upon the request of the Senate, waived the confidentiality of his bank accounts, thereby setting the standard of transparency in public service. Indeed, the innocence of the Chief Justice arises not only from the abject lack of evidence against him, but from his conduct, wholly consistent with a clear conscience. Truly, Your Honors, you are called upon to judge a man who has proven why he is the Chief Justice. After I speak, the prosecution will lace your ears with the last lines or even the last paragraphs, but their courtship shall be in vain. For borrowing the words of the counsel of President Clinton, theirs will not be the last voice, because the voice I will leave with you is the voice of reason, the voice of the law, and the voice of truth, the voice that will ring forever in your conscience. Your Honors, the other defense counsels and I respectfully request that you render a verdict of acquittal.
Majority Floor Leader.
The prosecution may continue. They have 40 minutes left.
Mr. President, before the second speaker for the prosecution speaks,